Good morning. Are you Melissa Taylor?
Yes, ma'am.
What do you have on your...
Oh, this is my son, Brandon Taylor.
Why'd you wear that this morning?
Because he's my entire world and he's messing me there.
Okay. Miss Taylor, this is your initial... No, you were here before. Did you get someone hired?
Ma'am?
Did you get someone hired?
No, I have contacted 4 different attorneys. I have the printout paperwork. I've got all the information. They're extremely expensive. I've not been able to get the funds gathered for that.
Who'd you talk to?
I spoke to, I have it down
Where?
a month ago.
Where'd you...
Wrap it in my phone.
Okay. Did you talk to some more since that last court date?
The last hearings.
Mm-hmm.
You asked, you instructed me to get 3 quotes.
Mm-hmm.
That was what I did. I can get that turned into you after,
Okay. If I test you this morning, you can have anything in your system? Have a seat in the jury box. We're going to text. Ms. Taylor, you tested positive for amphetamines, methamphetamines, and ecstasy.
And just like that, the courtroom mood changes instantly. One failed drug test doesn't just raise eyebrows, it triggers an immediate bond violation. The judge now sees Melissa as someone who ignored direct court orders, and that means harsher consequences. What started as a routine hearing has suddenly become a custody situation.
And so at this time, I'm going to find that that is a violation, obviously, of your bond conditions, and I'm going to raise your bond in your case to $100,000. Well, let me look at it real quick. I'm going to, let's see. In one of your cases, you're charged with assault on a peace officer, the other credit or debit card abuse. In each of those cases, I'm raising your bond to $100,000 in each case.
okay.
If you make the bonds in those cases, you are ordered to wear a drug patch at all time, get it tested at the appropriate times, and then we will move forward with your case.
Can I ask a question, please?
Mm-hmm.
Am I about to be arrested? And
Yeah, you're going into custody right now.
okay. I have a child.
You shouldn't be using ecstasy and methamphetamine. If you have a child, you can go back with the bailiff.
So I
Go back with the
have
bailiff
not
right
been-
now. Go back with the bailiff.
That moment hits hard. The judge's response is blunt: if you're responsible for a child, drug use isn't just reckless, it becomes part of the court's moral judgment. But then Melissa drops a shocking twist: my child is missing. Suddenly, what looked like a straightforward bond revocation spirals into something far more alarming. And the courtroom has no time to process it before moving on.
Go with the bailiff.
My child is missing, and he's with a terrible person.
Good morning, sir. Are you Christopher Paul Davis? And Mr. Davis, this is your initial. Good morning, sir. You're Denzel Lewis. And Mr. Lewis, you were previously in court, entered a plea of guilty to the third-degree felony offense of unlawful possession of a firearm by a felon. The agreement was for a cap of 6 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, sir.
Are there any additions or corrections?
Just argument from the defense.
Not from the state.
In addition, I have received the jail incident reports, which have been turned over to counsel. Have you both had an opportunity to review those?
I have.
Also, I have received this morning and now reviewed, it looks like 4 letters of support that Ms. Holmes brought today. Mr. Smith, have you had an opportunity to review those as well? All right, then Ms. Holmes, you may proceed.
Thank you, Your Honor. In looking at the PSI report, Mr. Lewis does have obviously previous criminal history spanning from juvenile and to adulthood. The priors that he has, it appears, with burglary of a habitation. It looks like 3 cases, but they ran concurrently, in which he was placed on probation and had a revocation, in which he was sentenced to 8 years in TDC. He has since been discharged from that, Your Honor. After being released, there was this traffic stop, which resulted in a firearm being found in the vehicle in which Mr. Lewis was driving. Obviously, in reading his response to the PSI officer, I would allow him to elaborate more on that. Obviously, he did plead guilty to the offense, taking responsibility, and we are seeking probation in this case, Your Honor. We believe that at this point in Mr. Lewis's life, he understands, obviously, being incarcerated before, that it's not somewhere that he wants to go back and spend potentially 6 additional years of his life. He would like this opportunity on probation to have that opportunity to spend and get back on track with employment, to take care of his family and provide for his family. And reading those support letters, Your Honor, he does have support here from family and friends in the community that are willing to step up and help him to make sure that he is a productive citizen and he gets back on track and understands that there's just certain things with being a convicted felon that he cannot do. And I think at this point he understands that, Your Honor, and we are asking that the court give him the opportunity to be placed on probation and to finish his term while on probation.
Well, I guess before we go any further, I want to make sure I understand, because
Now the defense is painting a familiar redemption story, a defendant who's made mistakes, learned his lesson, and just needs one more chance. Family support letters, promises to change, appeals for probation, it's all aimed at convincing the judge that prison isn't the answer. But judges don't just listen to promises, they compare words against patterns. And that's where things are about to unravel.
Mr. Lewis, your version of this is that it wasn't your gun, it was in your girlfriend's purse, and you didn't even know her purse was in the car, much less the gun was in the purse in the car. So either you are guilty or you're not guilty of the offense. And so if you knew about it, then you're guilty. If you didn't, then a jury needs to decide.
I'm pleading guilty because I was driving the car, and by me driving and then finding the gun,
But the law, that's not what the law is. Okay? So you don't get to just take a deal or plead guilty because that's what you want to do.
This is a critical courtroom moment. The judge isn't just questioning the facts, she's questioning the integrity of the guilty plea itself. If the defendant claims he didn't knowingly possess the firearm, then legally, pleading guilty makes no sense. And when your own explanation contradicts your plea, credibility starts collapsing in real time.
When you were here before, you stood in front of that clerk, you put your hand up, swore that you were going to tell the truth, and I said, are you pleading guilty freely and voluntarily? Or are you pleading guilty because you did what they charged you with?
And I was, and I still am.
Okay. All right, Mr. Smith?
Judge, I think he's been given probation before. It was not successful. He's been revoked. The actions in the jail clearly show he doesn't have any respect for authority or rules. I don't feel like he's a proper candidate for probation, so we're asking for a 6-year sentence in TDC.
So, Mr. Lewis, one thing I noticed in several of these letters that friends and family members said.
Then comes the detail no defense attorney wants the judge focusing on: jail conduct. Prior convictions may explain the past, but behavior while awaiting sentencing shows who the defendant is right now. And when jail reports suggest repeated disrespect for officers, especially in explicit ways, those support letters praising his respect suddenly lose all value.
I think 3 of them actually used the word respectful, that you're a respectful young man. What has been going on in our jail is the furthest thing from respectful that I've seen. The number of times, and the fact that I have to say this out loud, the number of times that you choose to masturbate in front of the officers on purpose is ridiculous.
Can I speak on that, Your Honor?
Sure.
The case wasn't on me. Somebody else had a case, and the woman even talked to the lieutenant to get it removed up off of my file, but it still shows up. That was not on me. It's somebody
It's
else.
more than one time.
But I
So
don't-
hold on. So on April 14th, let's just go through them. On April 14th, you were in trouble for not being in your bunk, that you had been given several orders to go to your bunk. You proceeded to walk around yelling, "Bitch, stop talking to me." So that's from April 14th, last week. Then on April 7th, it alleges that you had your hands in your pants, moving in and back and forth, that you were told to take your hands out of your pants, and that you had been told before, or this officer had been briefed on the fact that you were known for doing this. Your response, according to this, is that that person should have asked the officers how big your penis, anyway. Since they want to be talking about you, they should have told them about that too. Then, on March 25th, before that, a week, so another officer, and these aren't the same officers, it's not the same person saying the same thing about you, somebody has some vendetta against you. So on March 25th, started to do rounds. Notice that you were watching the person doing rounds. Had his hand over his midsection as if he was rubbing on himself. March 18th, another different officer. Notice monitoring the bunk. There you are, laying on your back, stroking your penis in a back and forth motion, told not to do so. January 24th, 2025, you're in trouble for walking around. This one, notice the way you're laying on your bunk in a way, making motions under the blanket, walked past, turned around to see if you were still doing it. Then you supposedly look at this officer and say, "I'm not doing anything," while you lifted the blanket up for that officer to see it. January 4th, another time, being told to be quiet, do what you're supposed to do, didn't do it that day. December 29th, another issue of not following the rules. December 17th, another infraction for arguing and not following the rules.